Good morning, Your Honors.
Good morning.
May it please the Court, Chris Foster for the Commonwealth. With me is Assistant District Attorney Ed Zabin, both the trial and appellate division prosecutor. The Court should vacate the single justice's denial of the Commonwealth's 211-3 petition and should also vacate the defendant's current sentence for assault and battery with a dangerous weapon and remand for resentencing. The appellate division has the very narrow authority to increase or decrease what they find to be an excessively harsh or excessively lenient sentence. In other words, they must find that a sentencing judge, in this case Judge McAvoy, abused her discretion in sentencing the defendant to the sentence that she did.
Are you saying the appellate division has to find an abuse of discretion?
I think they do. The only authority...
Have we ever said that? Is that anywhere in the statute?
Not those words, but I think if you look at Commonwealth versus Walsh, which also cites the legislative intent for 278, Section 28A and B, it specifically says that the appellate division has the authority to modify an excessively harsh or excessively lenient sentence. That's the only authority they have. So
it doesn't the statute also say that there really is no appeal from the decision of the appellate division?
Correct. There is no appeal, but there is always a remedy of 211-3, which in the Court's extraordinary powers.
And we review 211-3 decisions by a single justice under what standard?
Abuse of discretion.
Right. So why is it an abuse of discretion for the single justice to deny your 211-3 petition here?
I think it's both an abuse of discretion and an error of law because essentially the single justice is affirming what is an unlawful sentence.
So you're saying that the sentence of the appeals division is unlawful?
Correct. I think it's an arbitrary and capricious reduction of the defendant's sentence. I think if you look at everything...
Arbitrary and capricious? Without reason?
Yes.
Without rationale? Without rationale? No one could rationally come to this conclusion.
Correct. I do think that if you look at what the appellate division had before them, what's on the record at least, is a copy of the docket, the indictments, and possibly the party's sentencing memoranda. The prosecutor believes that he...
Was there any objection at the time by the prosecution as to what the record was before the appellate division?
No, and I think...
And so wouldn't that have been something for the Commonwealth to have done at the time?
It probably would have been preferential, but I think if you look at the practical implications, appellate division in Suffolk County at least happens about 2 weeks out of the year. And in the course of those 2 weeks, they hear almost 400 cases, 400 defendants with an average of almost 800 or more sentences. Each hearing is very short, very informal, where there's not even an official record of what's put before the appellate division. The papers are just handed over to the judges, and there's no record, nothing's marked for identification or anything like that for the public to look at. And I think here, the only things that are possibly before the court are the sentencing memoranda and short arguments by both parties. And out of all of that, there's nothing to indicate any mitigating factors.
We don't really know what was before them is what you're saying. And yet that's what you're saying. We don't really know what was before them, and yet on the basis of that, we can presume what was before them and it was inadequate.
Well, what we know was before them is the indictment and the docket. What both parties, both defense counsel and the prosecutor who were at this hearing both said that the sentencing memoranda were turned over to the judges. Other than that, I think it's very obvious they didn't have the trial transcripts. And that's just clear if you look at the docket. The trial transcripts weren't even prepared until after the appellate division ruled. So we don't even have that.
So you're suggesting that it would be arbitrary and capricious for the appellate division to make a decision without reviewing the trial transcripts?
No, I'm saying it's arbitrary and capricious here because they had nothing for which to find that Judge McAvoy sentenced the defendant excessively harshly.
Well, there was a presentation made by defense lawyer, right? An
Yes.
oral presentation?
Yes.
And then the prosecutor gets up and opposes the presentation?
Yes.
And so the prosecutor essentially has the last word that the three senior judges of the Superior Court hear is the prosecutor's opposition or the prosecutor's recommendation.
Correct. If you look at it, though, this entire hearing lasted 15 pages of transcript. And all that the defendant argued for mitigation is sentencing guidelines. As this Court obviously is well aware, those have no force of law. And the defendant was ignoring and calculating what he believed would be his sentence for assault and battery with a dangerous weapon of 6 to 30 months. Just isn't correct. The defendant was convicted of assault and battery with a dangerous weapon, but under Part C, where it's resulting in serious bodily harm. sort of minimum. And he also has a very extensive record, as Judge McAvoy explained. His record dated back till when he was 13 years old, and every year he had a different entry on that. He did time as a juvenile and time as an adult in the House of Correction.
So your view is that for each of those 400 cases, every litigant who is denied relief can come up to this court on 211.3 and say that there was an abuse of discretion by the appellate division in failing to increase, decrease, or alter the sentence. That's the entitlement of everybody before the appellate division?
I don't think so. I think it would have to be, of course, anyone in theory could file a 211.3. Whether or not that's successful is a different story. But what I think here is that the appellate division inferably could not have found, there's nothing presented to it with which to find mitigating factors.
Couldn't any litigant claim that there was an abuse of discretion and we would have to decide, according to you, we would have to decide all those cases and determine whether or not there was an abuse of discretion?
Well, I think the single justice would, but of course anyone really can file a 211.3, whether it's successful.
And you want to do briefing for each of those 400 cases, of which I'm sure the vast, vast majority are denied?
Yes, and I think if the defendant has a meritorious claim, then it would go forward. But I think here also the single justice abused her discretion in not at least ordering written findings. If you look at Commonwealth versus Gavin, which is a 1975 case out of this court, it just has a blanket rule that says we're not going to require findings, written findings, in these hearings, period.
So we've never required them, ever. And you're
Correct.
saying it's an abuse of discretion not to require them now all of a sudden?
I do. Well, I think it's an abuse of discretion is because although there were no express findings by the single justice, there is the authority to order written findings. Commonwealth versus Gavin even makes an exception, saying it probably would be a good idea in certain cases. We're just not going to make a blanket rule. The Superior Court can create that rule. What I'm advocating for is requiring written findings anytime the court increases or decreases a sentence. This enables the public to at least review what the court has done. If you look at it, obviously these hearings most of the deliberations have to happen behind closed doors. It's a panel of 3 judges deliberating. But while it's an informal hearing, there's no record of what is even before the court or what they consider in ruling. Essentially, the public has nothing on which to base whether or not this was a proper exercise of the court's discretion.
But, of course, the judge is not required to give his or her reasons when the judge sentences initially. Why is it different with regard to the appellate division?
Because all of that's taking place in the public. You have the whole trial that the public is allowed to look at. You have the sentencing memoranda. You have the whole clerk's file that the public can look at. The difference here is much like this court and the appeals court, deliberations take place behind closed doors, which then there's a production of some type of written conclusion which the public can scrutinize. So I think the appellate division, much like this court, needs to produce something when they change something where their only authority is to alter a sentence for excessively harsh or excessively lenient.
So the statute doesn't require it. We've never required it, but now it's an abuse of discretion not to require it.
I think the stronger argument is it was an abuse of discretion to not vacate the appellate division's sentence because it is on the record at least an arbitrary and capricious sentence because there's no mitigating factors. But
There have to be mitigating factors? I mean, why does it have to be mitigating factors? Simply a judgment by 3 senior judges, very experienced in sentencing in very serious cases, that the sentence was a little more than it should have been. I mean, you know, it was so that he got 25 years instead of 30.
I don't think it's an issue of just harshness. It's excessive harshness where no other conscientious judge would impose such a sentence.
Is that the standard, where no other conscientious judge would impose the sentence? Is that the standard
for
that the appellate division has to use? No other judge would no other conscientious judge would impose the sentence of 30 years, therefore we're reducing it to 25? Is that what the appellate division has to do?
I think so, in order to find excessive harshness or excessive lenience.
Well, how can you say that the no other judge standard is the one that applies here, where you have 3? You have at least 2 other judges that would have done it.
Correct, but we don't know why they did this.
But it can't be an abuse of discretion if 2 people agreed with the third. under the standard that you want us to adopt?
I think the fact that we also have a very experienced sentencing judge, Judge McAvoy, who's been doing trials, obviously, for a long time, and I think you have the fact that she didn't even sentence the defendant to the maximum for assault and battery with a dangerous weapon. She sentenced him to 8 to 10, where this resulted in serious bodily injury, which is up to 15 years. And I think the defendant's argument was looking at the sentence as a whole. The only sentence the appellate division touched was the assault and battery with a dangerous weapon. The defendant makes an argument that he won't get parole until later than he would have with second-degree murder. Obviously, second-degree murder, there's no entitlement to parole. That's a life sentence. So I think that argument's slightly disingenuous. I think here the only sentence to look at is the assault and battery with a dangerous weapon, which was well below the maximum that the judge could have sentenced.
Thank you, counsel.
Thank you.
May it please the Court. Good afternoon, Your Honors. Christopher Belazos on behalf of Casimiro Barros. I oppose, obviously, the Commonwealth's petition before the Court and would argue to the Court that the Commonwealth has failed to present any evidence that the single justice abused their discretion or violated the law in any way. I think at the outset, there are two separate issues that seem to be argued by the Commonwealth. And before they can get to the second issue, which is that the appellate division was wrong, they have to get by the first issue, which is to say that the single justice somehow abused her discretion or violated the law. There is no evidence before the Court that the single justice abused her discretion or violated the law in any way. The single justice looked at this matter, and I would also, although I didn't argue it in my brief, because I don't think it's appropriate at this forum right now, I'm not sure that the Commonwealth even met the standard for 211.3. They failed to demonstrate, in my mind at least, that they lost any substantive right, because there is no substantive right in question here. But moving backwards, the matter before the Court, before the single justice, two questions. Did they abuse their discretion or did they violate the law? They're looking at whether or not the sentence was legal. The sentence was clearly legal. It's 45 years. That's within the statute. Secondly, some question of abuse of discretion. There's no evidence at all that there's an abuse of discretion, except for the Commonwealth doesn't like the result. I mean, that's really why we're here. Commonwealth doesn't like the result. That's not the way, moving to the second issue, whether or not the appellate division is required to do anything else. The Commonwealth has argued since 1943, when they developed the appellate division, the Commonwealth has consistently argued and taken the position that the appellate division is final. Numerous defendants have come before the Court and said to the Court, I want you to look at my sentence. My sentence was increased. My rights have been violated. The Court has come down over and over and over and said, no, the statute is clear. 28A and 28B state this is a final decision. The Commonwealth makes note of the Gavin decision, saying in Gavin, the Court in essence said, you know, might be a good idea for the Court, for the Superior Court to ask the appellate division to issue reasons. That was 36 years ago. In the last 36 years, the appellate division has not been instructed by the Superior Court, which is what the SJC recommended or mused might be appropriate. In the last 36 years, since Gavin, the Superior Court has not asked them to do written reasons for this sort of thing. They have not asked them to do anything further. They make a decision. It's a final decision. All the players go to that court, go to that appellate division, knowing what the rules are. The rules are you go up there, you take your chances, you present your argument. If you lose, that's it. It's final. The Commonwealth can't come here now, after all these years, and say, not final because we don't like what happened. And that's in essence what's before the Court. There's no abuse of discretion. There's no unlawful sentence. Nothing of the sort. The sentence that they imposed had a basis in fact. Mr. Zabin, with all due respect, he was there. He made his argument. I made my argument. As to the issue of serious bodily injury, I think that there may be some confusion here. The injury, and I don't want to necessarily get into the facts, but the injury suffered by the party in the assault and battery dangerous weapon amounted to a bruise or a blood blister. The bullet bounced off him and fell out of his pants. So it's not that he had any serious bodily injury that a 15-year sentence would be appropriate. And I think that fact is uncontested.
What do you mean the bullet bounced off of him? What kind of a gun was it?
It was an exchange of fire. the victim in this case, unfortunately, was struck in a manner that she died. I mean, she suffered a terrible injury. But the other gentleman involved, Manny Andrade, was struck and went through his pants, and as I recall the testimony, left either a very slight wound or what amounted to a big bruise. Just didn't penetrate the skin.
Do I understand this correctly, that the sentence we're talking about is the A in assault and battery by means of a dangerous weapon?
Correct.
Trial court sentenced to
9 to 10.
8, was it 9 to 10? I thought it was 8 to 10.
8 to 10, I'm sorry.
8 to 10 from and after the manslaughter
Correct.
sentence. And that was reduced to 4 to 5 from and
Correct.
after the manslaughter. Okay, so that's what we're talking about.
And that, in essence, was the crux of my argument at the appellate division. I did argue for the record that I thought that the 19 to 20 on the manslaughter was excessive in that it exceeded the guidelines. But I conceded to the court, the panel at that point, that that wasn't my strongest argument, and it was not my greatest argument with the sentence.
And the 19 to 20 on the manslaughter remained?
Remains in effect.
Okay.
Remains in effect. There's no abuse of discretion here. There's no violation of the law. It's a lawful sentence. And this court, in the statute, clearly says you don't have a right to appeal it. What the Commonwealth is asking you to do is to change the rules because they don't like the result.
Well, I mean, if it had been an unconstitutional sentence or some sort of unlawful sentence, presumably we would, that's a vehicle for us to review such an extraordinary.
Completely conceded. But the Commonwealth hasn't met that basic standard to say this is an unlawful sentence or that this sentence is unconstitutional. There are cases out there which talk about, I believe it's the Walsh case, which talk about a judge perhaps considering crimes for which the defendant wasn't convicted, and the court always had the right to look at that. But that's not what we're talking about here.
Right. And we can also look at systemic issues through 211.3 if we thought there was a systemic problem in the way the appellate division was deciding.
I would agree, but in the 60-something years that it's been in effect, it doesn't seem to have popped up as a systemic issue. And I also would, again, point out that the Commonwealth has taken the exact opposite position they're taking now over numerous cases to say that there is no appeal and it is final. I think the quote that's included in the brief from Woodward is very much on point, that this court cannot review a sentence because of a sense of unease over the numbers which either the sentencing judge or the appellate division imposed. That's not what this court can review. Those sentences are final. It's not for this court to review. It's referred to the appellate division or perhaps back to the sentencing judge for reconsideration, but not here, not under these facts and circumstances. Is there anything further I'd rest in the brief?
Thank you, sir.
All right, please stand.